Argentina versus Weltover Inc.
The nature of this case reviewed denial of dismissal of action for breach of contract. The context of this case is important because it argued that a foreign government may be amendable to suit in a U.S. court for defaulting on its bonds. The key actors that are involved in this case are the Republic of Argentina bond issuer and Weltover Inc. bondholder.
Due to currency instability, Argentine businesses often had trouble participating in foreign transactions. In 1981, Argentina instituted a foreign exchange insurance contract program, the FEIC, under which it effectively assumed the risk of currency depreciation in cross-border transactions. When Argentina could not cover the FEIC contracts, it issued bonos or bonds which provided for repayment in US dollars through transfer on the market in one of several locations. Subsequently, when Argentina concluded that it lacked sufficient foreign exchange to retire the bonos or bonds, it unilaterally extended the time for payment and offered bondholders substitute instruments as a means of rescheduling the debts.
The question at hand then became, may a foreign government be amendable to suit in a U.S. court for defaulting on its bonds?
Argentina contended that it cannot be sued in a U.S. court for defaulting on bonds it had issued. Ultimately, two Panamanian corporations and a Swiss bank brought a breach of contract action in federal district court. The district court denied the motion and the Second Circuit affirmed. The U.S. Supreme Court granted review. In 1986, Argentina, facing a shortage of reserves of U.S. dollars, defaulted on bond payments. Several bondholders, who collectively owned $1.3 million worth of bonds payable in New York, sued for breach of contract in federal court in New York.
Argentina moved to dismiss, asserting sovereign immunity. In affirming, the Court of Appeals ruled that the District Court had jurisdiction under the Foreign Sovereign Immunities Act of 1976, the FSIA, which subjects foreign states to suit in American courts for acts taken in connection with a commercial activity that have a direct effect in the United States.
A foreign government may be amendable to suit in a U.S. court for defaulting on its bonds. The Foreign Sovereign Immunities Act of 1976 creates an exception to foreign sovereign immunity commercial activities. For purposes of the FSIA, an activity falls within the exception if 1. It occurs outside the United States, 2. Is in connection with commerce, and 3. Causes a direct effect in the United States.
Here, the first element without question has been satisfied. Whether a government's activity is commercial must be determined with reference to the nature of the act. The issuing of a bond is a commercial rather than a sovereign act. Private concerns can and often do issue bonds. It is not an activity given only to sovereigns.
Finally, an effect is direct if an effect is the natural and immediate consequence of an activity in question. Here, the effect in the United States was direct because the bonds were payable in New York, so the breach occurred there.
In sum, on June 12, 1992, the decision was made that the activities of Argentina with respect to the bonds were commercial in nature, so the commercial activity exception to the FSIA applies. The key to determining if that commercial activity exception applies in any given case is whether the government has entered the marketplace. If it has, it is to be treated under the FSIA as a private player. If it undertakes an activity particular to a sovereign, the exception does not apply.